Overview, talk a bit about, I guess, e.law and who we are and what we do. Talk about this beast, electronic evidence. And it is somewhat of a beast because even though I feel like I've been doing this forever, really it's only been around for a short period of time. I mean, when I first started practice as a baby lawyer, probably 20 years ago now, email was pretty much unheard of. It was really only just, it was unusual to have a computer on your desk. So in that time, we've gone from a system that's been around for centuries, a paper-based system, to one that is electronic and not just a static electronic environment. That again has just, it changed incredibly. So just as you get used to one way of doing things, it all changes. A good example of that is data being stored in the cloud. A few years back we actually had a computer forensics division which went out and obtained hard drives and notebook computers and so on. And it's a big thing that if fraud was suspected in a case, you could get the hard drive and actually find some of the deleted files. Well, that's all changed with so much being stored in the cloud, and I'll talk a bit about that. And then I guess taming this beast, which is electronic discovery, and what's that about, and what do the courts say, and is it really, does it have to be this complicated, and how can technology help? Again, because the information is in an electronic format, was created by technology. How can you use technology to get to the nub of what you're looking for at the end of the day? And then we'll talk a bit about technology-assisted review. Because we are using technology, the software that's being developed is really coming to the fore. And I won't talk too much about this, but there's some academic papers, there's lots of talk about are we as lawyers relying too much on the technology? Do we have to make sure that we follow obligations to make sure that we review everything? Again, what does that mean and what are the courts saying about that? So just a bit about e.law. It was established, e.law itself was established in 1999, but last year we actually merged with another company called Systematics, which was founded in 1979. So Systematics was actually a competitor to e.law, so we have very similar backgrounds, and Systematics has developed software which originated in, I think, the estate mortgage case back in the early 90s. So lots of experience in electronic evidence between us. We've both run, I think we both have significant firsts in running electronic trials, doing big discoveries, and really just, I guess, moving with the times as the technology changes. So why do I call it a beast? I guess there's so many things you can say there. That often there's a lot more data, I guess, than you would expect if you were just looking at hard copy. It's much easier just to store everything. Hard drives are really cheap these days. You can go down to CX Computers and buy a 1 terabyte hard drive for about $400 these days. Terabyte is a huge amount of material. So there's certainly, you certainly wouldn't want to just simply print everything out there. Often it's duplicated many times. Emails are duplicated because if I send an email to someone, there's automatically a duplicate sitting in their inbox in terms of what's sitting in my sent items. And it can be stored in many different locations. As I mentioned earlier, often companies now are considering putting everything in the cloud. So the first task, if you're involved in litigation, is to collect and retrieve the electronic information. So what are you looking for? Where is the data stored? What date periods are you looking at? How are you going to get the information? And then whose data is actually relevant. So you may only need email repositories for half a dozen people, for example. So that's often the first task, is actually finding the data. And of course, in terms of where it's located, often it's in many different locations. And we talk about cloud computing, that could be actually stored in different jurisdictions. So whether you're complying with the discovery order in terms of having to find the information, or if you're wanting information from someone else, that's a consideration that may need to be taken into account. I won't talk too much about, what if it is stored in another jurisdiction. I guess the worst case scenario is you may have to get a subpoena in that jurisdiction, but I guess that's another whole topic we can talk about. But generally just understanding where information is kept. Now for larger organisations you probably have a record, some sort of record manager who may be across that, or certainly your IT department. But at smaller organisations, it may simply be a server in the back room. So it really just depends on how big you are and how far back it goes. If you're looking at incidents that occurred, say, in the early 2000s, often information was simply archived to backup tapes. And backup tapes are a huge problem. I remember going into a client once who said, oh yeah, we've got all our stuff on backup tapes. And I said, okay, well, where are these backup tapes? And they took me down literally into the bowels of the building, and all these backup tape containers were simply stuffed under a stairwell. And there was something like 200 of them. And you open one, there's about 20 backup tapes in there with no labels, nothing. So, yeah, hopefully, hopefully you want your incident to only go back a couple of years, because something like that is simply just long and expensive. But it's not all bad news. I guess because it's in electronic format, it means too that it's in a form that can be searched, and I'll talk a bit more about that in a moment. But if you're looking at evidence, and I guess this is why we like to get involved as early as possible, because often companies will just say, oh, look, yeah, we'll just get our IT person to do that. Can you just go off and, get these emails, get these files, and then we'll hand them over. But at the end of the day, it is evidence. So you need to make sure that the evidence you're obtaining is obtained the right way, so it's not changed. We've seen some horror stories where people really do put their cases in jeopardy because you're manipulating the original evidence. So just making sure you obtain it so that it can stack up in court. And that's what I'm talking about. It must be authentic to be admissible, because if it's been changed, then there could be a question mark over the authenticity. And it must be relevant. So how do you find what's relevant to the issues in your litigation? So taming the beast, using the technology to help you find the evidence. What I talked about, making sure it's in a forensically sound manner, so that it's not changed in any way. And then looking at this issue of relevance, which is where electronic discovery comes into play. Now, I'm sure many of you may have been involved in a longish discovery in your careers, either as a paralegal or a junior lawyer in a law firm, or even managing a litigation in one of your corporates. But it can take a life on its own, and some discoveries, as we know, can go on for years and be quite complicated. The good news is that the technology can help with this. So why discover documents electronically? We still get requests to just print everything. Here's a USB stick, can you just print everything? Obviously there can be problems with that. Just printing out documents can miss the metadata that's contained in electronic files, and that could be relevant to your case. I mean, 9 times out of 10, it may not be relevant because you're looking at documentary evidence and looking at the content of it in terms of what people said. But sometimes that metadata can be important. If you're needing to know where in emails, for example, were sent from, who they were sent to, and where they stopped along the way. Metadata could be important because you need to see what changes happen to a document. So just think about what the issues are and whether the electronic evidence in a file is going to be important, because you don't get that in a paper version. And always make sure you can go back to the original document, even though the best evidence rule has been is no longer contained in the Evidence Act. You still do need to go back to the original if you have it. Both Federal Court of Australia and Supreme Court New South Wales have practice directions. The Federal Court Practice Note CM6 is quite clear. Printing electronic documents is a waste of time and cost and rarely necessary. Printing also means you lose the ability to search across the documents, and also printing can mean, unless unless a printed document has a reference on it, you can lose the ability to reference back to your electronic documents. So simply getting a USB and printing everything out can actually cause you a lot of headaches down the track, because if you need to go back to those electronic files, unless it's been done in the right way and properly referenced, you can get yourself in a bit of a muddle. And then searching today is more than just keyword searching. So I'll talk a bit about that in a moment. So what do the courts require? Obviously, documents must be relevant to the issues, and documents, you only need to find documents after a reasonable search. Now, the wording depends on which jurisdiction you're in, but certainly in the federal court, you only need to conduct a reasonable search. So here's the various rules. I won't go through them all. I think probably the most relevant here today, depending on where you're from, would certainly be the federal court. So you need to find what you can after a reasonable search and what is directly relevant to the issues in the pleadings. New South Wales, relevant to a fact and issue, and as I mentioned earlier, if you're in the equity division, there's a practice note that basically says an order for discovery won't be given until your evidence has been placed with the court. And so you need to actually get a specific order for discovery. Some people sort of wonder how that can be the case. How can you know what your evidence is until you've had documents discovered? But so far, that seems to be working quite well. And then the various rules in each of the other jurisdictions. So I have Queensland, Victoria, South Australia, Western Australia. So they're all fairly similar. Tasmania, Northern Territory and ACT. So how do you find what's relevant? So first port of call, as I mentioned earlier, think about what you need to obtain. So you go, if you're a larger organisation or a smaller organisation, you need to know where your information is stored. How are you going to obtain it? What date periods are relevant and whose information do you need to obtain? Just better keep an eye on the time. 5 minutes? How long have I got? Okay. I might just run through this quickly. We've only got a few minutes left, and I want to leave time for questions as well. So we've actually got an international standard that we work to, and just to explain this, you'll see on the left-hand side, I've got a triangle where it starts out with a large volume, and as you go through the processes, which ultimately ends up as presenting your evidence in court, then your relevance will increase. So less documents, more relevant. And this is where I want to talk about the technology to help you find what is relevant. And there's obviously keyword searching you can do across electronic documents, but now we have tools that are known as technology-assisted review. Concept searching, predictive coding, clustering, categorisation, email threading, near duplicate detection. Keyword search is good, but they can be ineffective. To give an example, in one of the data sets we use, the Arthur Anderson fraud case, they used code words, Jedi, I think they were Star Wars characters. So with a plain keyword searching, they're things that you could miss. What the technology here does is that by clustering groups of documents together, which is one way to do it, it allows you to see documents that are a similar concept and give you an idea of what the data set contains. Another way to do it with the predictive coding is to train data sets to understand what documents are relevant. So we've done a case study recently with one of our law firms who did a relatively large matter. They did a manual review of a large data set, and then we then compared that with using this technology to help find. Now we've got that study available. It's available from our website. There's also some academic publications from America which compare the use of this technology, and essentially you do tend to get a better recall and precision rate by using the technology combined with senior lawyers training the technology. So, as I said there, what these studies show is that you get a higher precision, so the number of documents reviewed that are actually relevant, and a higher recall, so the amount of relevant documents that are missing and not reviewing at all, because obviously the aim is 100%. Interestingly, in the US, we don't have any decisions which consider the use of this technology in Australia, but in the US, Judge Paech has given some seminal decisions on this and is basically saying, look, unless lawyers are using this, then they're not doing their jobs properly. We had Judge Paech out here last year actually talking to the profession about this and giving his views on how best to use this technology. So how it works, just to give you some visuals, here is an example of a concept search. So what the technology does is index all of the words in all of the documents in the whole data repository that you have. And then it, instead of just giving a thesaurus, it will give you words that are of similar concept based on what it's found in the document. So here you can see we've done a search for the word fraud. And you can see you get accountant, Anderson, Arthur, and a whole host of other things that you wouldn't get an ordinary keyword search. So if you didn't really know what you were looking for, you can see the obvious benefit of this technology. Clustering is a way of grouping together documents that are of like concept. So you can go in here and see, for example, that top one, Rabarski-Nelson, has 1,167 documents in it, which are all about 90% similarity. So you can go in, and what it allows you to do is to review those like documents very quickly together. And if you can think about if you had the old way of doing things of paralegals in a room, say you had 6, 10 people, person one might see one of those emails, mark it as relevant or not relevant, and another person on the other side of the room might think it's so if the first person marked it relevant, they may think it's not relevant. And so immediately, because you don't have it in context and different people are looking at it in a different light. Here, you can look at it in one foul swoop. Duplicates and near duplicates. So the technology will automatically identify exact duplicates. So you can get rid of any of those. The more difficult one is what we call near duplicates. So that's scanned versions of a hard copy of an electronic document. Now, they will never be exactly the same because the OCR technology, is not 100%, or it could be different versions of things. But as lawyers, you want to know that, they need to be brought together, and the technology can do that. So here in an example, the software says, I've got my master document, the third bottom and the second bottom are exact duplicates, and the others are near duplicates at about 87% similarity. You can see all those together. The software allows me to see the differences automatically. So this is like getting the word compare in a document, and I can compare one to the other to immediately see what the differences are. So you can see here this has been a forwarded email, and I can see what changes the person's made there. So very powerful. Email threads, again, if I send an email to someone, you might have 20 iterations of that. You just want to see the top email with all the threads. Have the other ones available. If you need to see them, they may have other attachments and so on, but you want to actually see that email thread together. So for it to be used, now these studies I mentioned earlier are always asking the question. It needs to be as accurate, if not more so, than a traditional review. Lawyers need to be convinced that if we're not eyeballing every single document, are we sure that we're doing our job properly? So I think the general consensus is, nothing's as good as a senior lawyer looking at a document, but certainly the technology is much better than what we had previously. Also, the court standard is reasonableness, not perfection. And I've heard judges say this before, that we want to make sure that the client gets a good result from this without having to spend a fortune. If they can get, a Holden rather than a Rolls Royce, at least they're getting, a car that will get them from A to B. So it doesn't have to be perfect, it just has to be significantly better than the alternative. Now, all of this hopefully results in you as clients, as answering to the CFO, and saving you money. And as I mentioned earlier, this is all about planning up front, making sure that you understand how the technology works and how it can effectively help you to get to where you need to be, which is getting a set of documents that are relevant, that can be ultimately used in your witness statements that will end up as evidence in court. And you know, if you can get that advice on evidence early and work backwards from there, then your targeted searching using this technology, hopefully, you know, can end up saving a lot of you know, manual work that might otherwise have gone on. So I have any questions? Yes.
You've quoted Justice Paech in the US quite a bit. Is there any Australian jurists that are supporting it in this way, or is it just the rules of court?
Yeah, we don't, to my knowledge, we don't actually have any decisions in Australia on this yet. I know that the judges, certainly Justice Hammerschlag is supportive. Chief Justice Martin in Western Australia, he's presented or been involved in conferences and he's actively supported. You know, again, just saying, look, you know, if you can use whatever you can that is going to save you cost and end up with the same result, and also they always, you know, judges always say, well, we're only interested in the 20 documents that prove or defend your case. So if you can get from this much information to those 20 documents in court without having to spend millions of dollars, then, you know, they fully support that.
Thank you, Alison. One of the risks I see with technology and discovery is the increased risk that it's very easy to put millions of documents on a disk other than in an A4 folder. So the receiver may end up with little gems, namely legal advices, that inadvertently may find themselves in documentation that's been discovered. I'm aware that there's a case in this it might have been in this jurisdiction where
yes,
there was a very expensive interlocutory fight between the two parties.
Yes.
I'm not sure whether that case involved electronic discovery, but the
It
principles are still the same. And I understand that was eventually resolved by the court, saying, well, it was unethical for the receiving party to even have looked at it, and well, it was unethical. It was ethically, what should have happened was that they should never have looked at it, and I suppose that could lead to a situation where a law firm may have to conflict itself on ethical grounds from acting for a particular party. Now, if you've already spent $500,000 on your top tier law firm in starting the defence of a case for you, and you end in that situation, naturally that's going to be very costly for the business. So looking at it from the perspective of the receiver, what ways can the receiving party use technology, and what strategies might there be to put the receiver of discovered documents in a situation where they're not placed in that situation?
Yes, no, that's look, I think discovery of privileged documents keeps every litigator awake, and we actually spend quite a bit of time with the lawyers doing those privilege checks before documents are sent to the other side. I know the particular case you're talking about, and yes, the discovery was undertaken electronically, but really it was still a large amount of it was done manually. I think the technology that we've got today can actually help you do that final discovery or the privilege check. And to give you an example of that, one thing I didn't show you there is the technology actually has what we call a similar documents finder or locator. So what you can say is, okay, in the data set we've now marked, let's say you might have 30,000 documents that are potentially discoverable. You've now done the review and you've marked, say, 1,000 of those as privileged. What the technology allows is, are there any other documents in the 30,000 that are similar to these 1,000? Now that gives our clients a lot of comfort, because that may bring up other privileged documents that haven't been found on the traditional keyword searching. You search for solicitor names, law firm names, counsel names, things like that. And because it may have been sent from a personal account, or they might have done a Hillary Clinton and sent it from their personal account at home or something. So, you know, I think the technology, if used effectively, can actually really benefit. Now, I think, look, you know, nothing's perfect, and there still may be, you know, disclosure of documents that are privileged. That may be done inadvertently, and that's why I think, you know, those rules are around there, so that if a receiver, if you do obtain a privileged document, the first thing you need to do is get on the phone and say, look, I think this is privileged, we haven't taken it any further, give the disc back and make sure that, you know, those are covered off, because it does have, as you mentioned, serious consequences if that's not done properly up front.